for this Federal Grants Management 101 training. Let's see, Scott, did you want to introduce yourself? Or I'll introduce myself first. So I work at Feldman Tucker. My practice includes representing federal grant recipients, and mostly in the areas of social services and healthcare, advising them on a wide variety of grant-related issues. And where I usually get involved is in areas where there's maybe a bit of a problem, including issues such as audits and cost disallowances. And in addition to kind of the federal grants work, I also work on the healthcare side of Feldman Tucker, mostly representing community health centers that receive federal grant funding, dealing with issues relating to Medicare and Medicaid payments and reimbursement and compliance related issues. Scott.
No, thank you, Kathy. And so good. I guess it's still good morning to most of you. I think all of you. Good morning, everyone. So Scott Scheffler, I'm a partner here also with Feldman Tucker. I practice primarily in the area of federal grants. I work with healthcare entities, but also outside the healthcare context. And so I do a lot of work really across the government in various programs, from scientific research to conservation to healthcare to social services to things that sort of cross over all of those areas, and dealing with mostly the issues that arise when something goes wrong with a federal agency. But also I'd say I spend about 40% of my time doing compliance counseling and helping with transactional work. So subrecipient agreements, contracting, et cetera, federal procurement standards, stuff like that. Before I worked at Feldman Tucker, which has amazingly been, I think, 9 years now, even though it feels like 3, I was an attorney with the Navy, and I actually worked on the federal side in government contracts. So advising the federal contracting officers, which is kind of like the grants officers, but with a little bit more of a rigid framework. As far as the way we'll approach the presentation today, please ask questions as we go. Type them into the chat. I know everyone's muted. We will keep an eye on the chat. I can see it up on my other screen here. You'll see me looking to the side periodically. But post your questions as we go and we'll answer them. If it becomes overwhelming, we'll not be shy about letting you know. It's hard. I'm setting myself up for failure here, but I think it's hard to overwhelm us with questions. And then in terms of other housekeeping, we are lawyers, and in fact, we do represent TCCN, as you know. The purpose of today's presentation is not to provide legal advice to anyone. We're lawyers, and we come at this from the perspective of what the law is and what we believe the law means. But we're not providing anyone with legal advice today. We're simply providing you with technical assistance, training, and education. So please take it as that. In terms of the materials, I know that our training team puts out information to our partners on how they can use the materials. I will say, whatever variation that is, please feel free to keep copies of these materials for your internal use, print them out, share them with your colleagues internally. We just ask that you don't post them on your website, distribute them to listservs, et cetera, though I know TCCN is distributing them for purposes of this webinar, and that's a good thing. So what we're going to talk about, and then I'm going to talk about the agenda for today, and then I'm going to turn back over to Kathy to get us through the first piece. We want to talk about this particular presentation. I'm pretty certain that we are all set to do a follow-on presentation on procurement. This particular presentation is a relatively high-level know your system presentation. One of the things that we encounter, whether it's like Kathy was talking about in healthcare reimbursement, or whether it's in the grants context, or whether it's when I work with government contractors under the federal, the federal acquisition system, is that to know what your options are and what your obligations are, to know where to evaluate risk, high risk, medium risk, low risk activities or issues, you really need to start with an understanding of the system. And so that's what we always like to start with in terms of presenting on the grant system. And in talking with TCCN, we thought that was the best place to start in terms of any sort of training and education we're providing on their behalf. So I'm going to talk about how the grant system, once Kathy sets the stage, I'm going to talk about how the grant system is set up. And then I'm going to talk about within that legal system, which when I talk about the legal system, it's going to be a little bit overwhelming. You're going to say, oh my goodness, there's so much stuff we need to know. But I'm going to provide you 3 tools, actually, that will be very useful tools in being able to sort of run down specific answers to all of your myriad questions within that system. So there's a way to actually sort of navigate the system. Then I'm going to talk about the deal. That's the most important thing I'm going to talk about today, because the fundamental nature of the deal between you and your funder, or between that, in this case, you and TCCN, or in TCCN's case, TCCN and the federal government. In this presentation, I'm going to talk as though everyone's directly federally funded. So I'm going to talk about the deal between you and the government. There are 3 key aspects to that deal, which is what all of the sort of terms and conditions in the grant agreement, or maybe not all of them, but 90% of them are about. And they're the ones where if something goes wrong, you pay back money. And so that piece I want to really emphasize. Understanding the nature of the deal is critical in the grants context. Once you understand that, very easy to issue SPA without knowing all the little sort of myriad rules. And then what I want to talk about, sort of what happens when, okay, if you're a grantee, but you're not going to perform the project alone, you've got contracting partners, subrecipients, et cetera, that you'll work with, or maybe you are a subrecipient and you're working with a what I would call a prime recipient that then is flowing funds down. How do those relationships work under the applicable federal regulations? And they're very different things. Contractors have one set of rules and subrecipients have another set of rules, and they are different sets of rules. And then we'll talk about cost allocation and a little bit about indirect costs. I don't want to go too far down into the weeds on this, so I'm going to do an overview of the core considerations in cost allocation, and then I'm going to describe what indirect costs are and how they work. From there, if we wanted to do additional training and education, if you want that, if TCCN wants that, where we really get down into the weeds, we can do that. Today, we're going to provide an overview. And then lastly, one of the high-risk areas for grantees when they expend funds on equipment or other capital assets, real property improvements, though I doubt you're doing any of that, but acquiring equipment, there are long-term tail obligations. And so I want to talk about how that sort of part of the system works. And it's generally described as the concept of federal interest, the idea that the federal government acquires an interest in that capital asset for some period of time. So we'll talk about that. So that, Kathy, do you want to kick us off?
Sure.
Oh, we do have poll questions as we go. And actually, maybe Mary, is there a way to launch polls, or are we just answering them in the chat?
We will just answer those in the chat.
All right. So by quick show of hands in the chat, if you could type, instead of just the letter, type just the word, what best describes your role in your organization? Are you a finance person, non-finance leadership, a program manager, purchasing official, we have to fix this, a development office or grant writer, or something else, or all of the above? All of the above, just put, I'm not sure, finance. Usually it's finance who gets tasked with all of the above.
And you'll notice that these poll questions are a way for us to get to know you all a little bit better. That way it's not just a one-way street of us talking.
Seeing them come in, lots of program managers and a handful of finance. Usually we have lots of finance. So this is finance/grant writer. So that person has a very exciting existence. And Kathy, I'm happy to advance your slides. Thank you. All of the above. As we go, just let me know.
Oh, that's great. Thanks, Scott. So I thought it would be helpful to start off with a little bit of background and look at federal grants management through the lens of TCCN's funding and the funds that TCCN is actually receiving at this time. So Scott, if you could go to the next slide. And the funds that we are focusing on here is the federal funding from the U.S. Centers for Disease Control. And those federal funds are being filtered through the state of Tennessee's Department of Health. And then there are 2 grant contracts that the Department of Health has with the Tennessee Charitable Care Network. So, and I put the grant contracts reference there in quotes there, because that is the term that the state of Tennessee uses for the 2 funding vehicles that it's using to pass funds on to TCCN. You're going to hear Scott talk about subrecipients versus contractors, and it's just kind of a funny terminology to me to say grant contracts. Why choose between grants or contracts when you can call them a grant contract? So just pointing that out. So Scott, if you could go to the next slide, please. And so just as I said, there are two funding streams, two funding vehicles from the state of Tennessee to TCCN. And the first one being focused on community outreach. That grant contract is actually is very much focused on education with respect to the COVID-19 vaccine, trying to promote education and awareness of the vaccine and to engage the community in promoting vaccination efforts. So that's the first funding stream. And then the second one is more focused on COVID-19 risk reduction in underserved and rural communities. And there's a focus on the community health workers. So that's just some background about the actual federal grants at issue here, as you're going to now hear Scott dig into the actual meat and potatoes of federal grants management. Scott, back to you.
All right, thank you, Kathy. So the CDC is fundamentally operating within a system, sort of like the Matrix. There is a system that exists in the background. And there are two diagrams that I have to describe the system, which I think are fairly telling. The first diagram is fairly straightforward and will tell you sort of a piece of the puzzle. The next diagram is a little bit more daunting, and we'll really start to fill in the details. So let's start with the easy one, then we'll work our way into the detailed one. And then after I talk through the detailed one, I'm going to talk about some tools you can use to make the detailed one not seem scary. So generally speaking, when the federal government wants to engage in what it calls, at least in the grants / contracts context, extramural activities, it wants to take, the federal agency has some goal that has a public purpose, and it wants to carry out that goal in some way by having non-federal entities participate in the activity. It really has two options. And I say non-federal entity really broadly because these non-federal entities can be state governments, local governments, tribal governments. They can also be nonprofit entities. They can be for-profit entities. Generally speaking, what the federal government will look to do is make a determination initially between whether it wants to use a service contract, assuming that what it wants you to do is engage in activities. If it's just buying supplies, it's always going to use a supply contract. But a service contract or a financial assistance agreement. So there are two separate systems that exist in the background for the federal government. One is the federal acquisition system that's governed by the Federal Acquisition Regulation, the FAR. And that is an entire world, sort of its own system, where if an agency wants to acquire services, it's really goods or services for its own consumption and carrying out its mission and carrying out that activity that has a public purpose, it does that through a procurement contract under the Federal Acquisition Regulation, and that's the system you're in. That's the sort of pink side over here. What we're talking about today is the other, essentially half of the system, the financial assistance system. If what the federal government wants to do is to take something of value that it has in its possession, most commonly cash, but not always. In fact, with CDC, they have what they call STI awards, which are for sexually transmitted diseases. Maybe the eye is infection. And in those, the context of that grant program, they will actually provide in-kind support in the form of supplies. But so broadly speaking, if what the federal agency wants to do is take something of value that's in the possession of the federal government, most commonly cash, and convey it to a non-federal entity to encourage that non-federal entity to engage in an activity that has a public purpose, it'll use either a grant or a cooperative agreement. There's also loan guarantees, but we're not going to get into those today. So one big difference between the procurement system and the financial assistance system is that for a federal agency to take something of value that it has in its possession and convey that to a non-federal entity, it requires an act of Congress. The agency does not have inherent authority to do that. Agencies have inherent authority to enter into contracts to acquire the stuff they need. They do not, under the Constitution, have inherent authority to take federal property and pass it along to a non-federal entity. What this ends up meaning is that when we get to the next slide and talk about the system, every single federal grant program or cooperative agreement program has an authorizing act. There is somewhere in the US Code where Congress has said that you, federal agency, are authorized to or shall make grants or enter into cooperative agreements to do this thing. And that's actually the first place we look for rules, and I'll talk about how that works. Within the financial assistance system, the vast majority of financial assistance is actually awarded to state and local governments and tribal governments. And then those state, local, and tribal governments will subgrant the funds down typically to community-based nonprofits, especially at least in the healthcare and social services sector. They'll subgrant those funds down to local entities that will actually be providing the services within their communities. What happens within this system, and I'll show this to you, is that when the federal agency makes the award to the state, one of the conditions on that award always is that the state then makes, when it makes the subawards, that all of the terms and conditions of the program of the prime award flow down to those subrecipients. And then those subrecipients can even further make subawards within their communities to sub-recipients. And so in a sense, if we think about TCC, what we're talking about here, like TCCN's role in these CDC programs, is CDC has made an award to the state of Tennessee. The state of Tennessee has made an award to TCCN, and TCCN has made numerous subawards to all of you. And so you can see sort of the flow down through the system. But one of the hallmarks of the grant system is at every level, and this is actually specifically required by 2 CFR 200.101B or 45 CFR 75.101B, if we're talking about HHS, specifically require that the terms and conditions flow down through the system as the funds cascade down, or the other thing of value. So in terms of the rules that apply, you're not supposed to be able to really read this slide. This is a picture is worth 1,000 words slide, and probably looking at it, you feel like it's worth 1,000 words. But within this framework, then, within the legal framework in the grant system that I'm talking about, that I've sort of described already, the terms and conditions that apply to your federal awards are governed by a hierarchy of background laws. And this is one of the challenges. If we go back to the federal procurement system, when you receive a federal procurement contract or subcontract, it's nice because you can just you can literally read the thing and know what you're supposed to do. That is unfortunately not necessarily true in federal grants. Now, if you have an effective subrecipient agreement in place, if the funds are passed through a pass-through entity, a prime recipient or a subrecipient that's a sort of operating like the prime recipient to you, it may be the case that the prime recipient does a better job than the federal government of actually laying out all the terms and conditions. I know oftentimes that's one of our goals in drafting subrecipient agreements, is to make the obligations more clear than what you would see in a notice of award directly from the federal government. But if you were the recipient of a direct HHS award, and some of you may be, in fact, you would see in the notice of award that all they say is basically comply with the law and carry out the activities that were in your grant application. They don't actually lay out all the compliance obligations at that prime level. So it's on you as the grantee to know those requirements and implement them. And that can be tricky. This pyramid reflects sort of the background web of requirements. And again, in a minute, I'm going to talk about how you research this. First and foremost, requirements arise out of the authorizing act that creates the program. And then secondarily, there are additional requirements that are layered on year over year through the appropriations acts at the federal level that fund the program. So every year HHS is funded through a consolidated appropriation that includes HHS, Department of Labor, and Department of Education. And every year in that appropriation are certain riders that impact grants, certain additional limitations, sometimes they're called legislative mandates, that are in those appropriation statutes that impact how you perform your grants. So for example, you may have heard that in HHS awards, you can't pay a rate of pay with federal grant funds that exceeds the executive level 2 rate of pay for federal employees. And you maybe thought to yourself, well, where does that come from? That's an appropriations rider. You may have heard in HHS awards that you can't use the funds except in certain circumstances for very limited circumstances for abortion services, except in fairly broad circumstances actually now, for needle exchanges, things like that. You can't use the funds for lobbying. You can't use the funds for any relationship with the organization Acorn. All of these things are stuff that just year over year as hardy perennials show up in the appropriation statute. The good news is, if you want to know the HHS appropriations limitations, NIH and HRSA do a pretty good job year over year of issuing guidance documents that list them out, so you can find them. Below the statutory level is where a lot of the action happens from a grant management perspective. For about 60 years now, there have been government-wide rules in the form of guidance documents that have been adopted by all the major grant-making agencies that govern how you manage your federal funds. In late 2014, early 2015, those various guidance documents were consolidated into a single sort of common rule called the Uniform Guidance that applied government-wide. And it's promulgated, it's codified at 2 CFR Part 200. You will see a lot of references to 2 CFR Part 200. That's really the cornerstone of the grant system. And again, it has been for 60 years. Prior to 2014, there was no 2 CFR Part 200, but there were OMB circulars that said essentially the same stuff that's now all in 2 CFR Part 200. So the system hasn't really changed much. And so 2 CFR Part 200, and I'll talk about 45 CFR Part 75 in a minute. It sets forth your basic grants management requirements. They've been consistent for decades, and they're government-wide. Now, 45 CFR Part 75 is actually what you as healthcare providers will most commonly encounter. What happened in 2014, 2015 was that OMB issued government-wide rules at Part 200, 2 CFR Part 200. Every federal awarding agency adopted them except for HHS. HHS adopted them and restated them in nearly identical form at 45 CFR Part 75. So just as a matter of course, if you see 2 CFR Part 200, for example, in a state of Tennessee document, just read it as meaning 45 CFR Part 75. In most of what you do, you should see references to 45 CFR Part 75. I suspect, and I believe the way that we've assisted TCCN, all of our references in your subrecipient agreements are to 45 CFR Part 75. That's actually directly applicable to you. But if you see stuff in state of Tennessee documents, because they manage a lot of awards outside of healthcare, to 2 CFR Part 200, don't let that throw you. Some programs will have program-specific regulations. Many healthcare programs do not have program-specific regulations. Good example of a program that has no program-specific regulations is the Ryan White program. By comparison, an example of a program that does have program-specific regulations in healthcare is the Health Center program, the Section 330 Community Health Center program. There are, in addition to program-specific regulations for a particular program, which may or may not exist, and the uniform guidance, which is always your starting point, there are other sort of cross-cutting requirements I'm not going to get into today, but things like suspension and debarment regulations, rules about drug-free workplaces, anti-discrimination requirements, etc. Those could each be their own webinar. We're not going to get into them in detail today, and they're not going to drive your day-to-day in the way that the uniform guidance does. And then below the uniform guidance, below the regulations, I should say, below the statute and regulations and the hierarchy, are all the guidance documents that agencies issue. Most grant in healthcare, I would say, in HHS, most of the grant programs, the federal agency will issue guidance. And those guidance documents end up being where you spend a lot of your time as you try to understand what your compliance obligations are. But technically, those guidance documents really are supposed to simply be interpretations of how the agency is implementing its your regulatory obligations and statutory obligations. But as a practical matter, and I'll give you an example of this, you'll end up looking at the guidance quite often. One of the things that agencies do that is actually very useful is that most of the major grant-making agencies have an agency-wide guidance document that reflects their interpretation of any gray areas in the uniform guidance. So to the extent that the real bedrock, cornerstone, foundational set of rules that you should be focused on for grant management, and this is the case, it is, is the uniform guidance. So for you, 45 CFR Part 75, to the extent that you're thinking, well, if there's a gray area, how does HHS interpret it? Outside of NIH, there's something called the HHS Grants Policy Statement, which is a roughly 200-page guidance document that provides additional information about how HHS interprets the uniform guidance. Within NIH, there's an NIH Grants Policy Statement. It tends to be more focused on research. Unless you're doing research, you won't look at that one unless you have NIH awards. But so for HHS, it's the HHS Grants Policy Statement. There can also then be program-specific guidance documents. I'm going to show you an example in a minute for the Ryan White program, given that you're healthcare providers, and Ryan White's a fairly stable program of what they tend to issue in terms of guidance documents. Understanding that for TCCN, you're not performing Ryan White services, but it's a useful example. One point of caution on the HHS Grants Policy Statement, if you pull it up and look at it, amazingly, and I make fun of, or I should say I pick on HHS a lot for this as well as other things. They haven't updated it since 2007. So if you go and you read it, it actually references the predecessor OMB circulars to 45 CFR Part 75. But because the new rules in 2014, 2015 really weren't new, they were just a recodification of the old rules for the most part. The grants policy statement still works because it's just the references are wrong, the cross references are wrong, but the content is still valuable. So to take an example, and so this is actually, I think, Kathy, you probably have you updated this? Is this where this comes from? Okay. So to take an example of, so for example, the awards that you're performing for TCCN, the statutes that are in play, right, set the baseline sort of framework of what's possible for the federal agency. And then the grant, there are no program-specific regulations for these particular funding streams, but you do have 45 CFR Part 75 for your grant management requirements. And then in terms of guidance, the HHS Grants Policy Statement. So in the way that I described it, I want to give an example of how to work your way through this. So I'm going to ask this question here, this poll question, and then I want to give an example of how to kind of work your way through these issues or these items. So how long have you worked with federal grants? Less than 2 years, 2 to 5 years, 6 to 10 years, or more than 10 years? Go ahead and just put in 2 to 5, 6 to 10, or more than 10, or even the specific number of years if you want to in the chat. All right, lots of less than 2. So this is good. This is good in terms of how we're approaching the presentation. Oh, so I got a more than 10. Everyone, keep track of who says more than 10, because that's who you want to call all the time. All right. So before I get into the deal, I want to share some resources. So I promised you, well, this is a lot of information. How do I figure it all out? So I'm going to let me switch what I'm sharing in terms of my screen here. Bear with me. I'm going to share my other screen. And I'm going to show you, so this is how, when I'm evaluating, you see me looking to the side here because I'm looking at my other screen. When I'm evaluating a new funding stream, the first thing I recommend doing when I'm trying to get my arms around the pyramid that I showed you in terms of now this particular funding stream. So actually, I'm going to back up. First and foremost, if you're a subrecipient, read your agreement. If the agreement is well drafted, that is going to point you to a lot of this information. But if you're a direct recipient of the federal government, or if you're a direct recipient even of just a state government, a lot of this, you're going to be on your own to sort of figure this out. So the question was, well, how do I figure it out? Well, if you go to sam.gov, and all of you have been, or I should say someone within your organization has been to sam.gov, because to receive a subaward, you have to have a UEI, a unique entity identifier, which you actually get through sam.gov. But in any case, so one of the features of sam.gov is that it actually provides a list of all of the federal grant programs, and this is required. It used to be called the Catalog of Federal Domestic Assistance, and now it's the sam.gov assistance listings. And so you can actually search every single federal grant program. All of them under the uniform guidance are required to have an entry, and before the uniform guidance under OMB circulars, they were all required to have an entry. If you should generally, every grant program has an identifying number. I happen to know that Ryan White Part C is 93917. I think part C is 93,917. Either part C or let's check. So Ryan White, HIV care formula grants to states and territories. I'm sorry, this is part B. So Ryan White part B is 93,917. So I searched it. If I want to learn about Ryan White part B, I can check the assistance listing. And this gives me a lot of really useful information about the program. It points me to the statute, the authorizing act. I can go read that now. It tells me who are eligible applicants. So in this case, it's the 50 states and the certain territories. I think it's 6 territories. Who are eligible beneficiaries of the services. This becomes a big deal in Ryan White. It's only individuals with HIV. Oh, sorry. How can the assistance be used? Generally speaking, this brief description in sam.gov will point you to key limitations, things like administrative cost caps, etc. And then we scroll our way down. What elements of the uniform guidance apply? Most importantly, I want to look for does subpart D, which is all the administrative requirements, apply? Does subpart E, the cost principles, apply? And does subpart F, the audit requirements, apply? And for most programs, the answer will be yes to this. This is a great starting point for researching any new funding stream if the agreement that you receive isn't particularly detailed. The next thing that you can look at is, so the way that this compliance system works, I'm not going to get into this a lot today, but the way that the back-end compliance system of audits works is that you have to go out and get a private audit, and the private auditors come in. If you expend more than $750,000 in federal awards in a year, you engage an auditor. They come in and they're going to do an audit, and they'll do compliance testing. Well, the auditors don't know all the rules either in all these programs. And so there's every year, OMB actually issues, with the help of each federal awarding agency, which provides them information, a compliance supplement, which is a really useful tool up front for you as well as the grantee when you're trying to make sense out of the requirements that would be imposed by virtue of that pyramid. Kathy, can you see, if you just nod for me, I can see on the screen, can you see the compliance supplement? Okay. So then what I like to do in the compliance supplement is take a look at, well, wait a second, does my particular award show up in here? Well, good news. Just like everything else in the grant system, the CFDA number, now called assistance listing number, is my street address every time I'm trying to find a particular program. So it turns out Ryan White Part B is in the compliance supplement. So there's an entry. Let me go find it. Here it is. So at page 1,679 of this document, there's an assistance listing description in the compliance supplement for Ryan White Part B. Not every grant program is listed in the compliance supplement, but if the program that you are under which you're performing an award is listed, this can be a really great sort of shortcut for high-risk items, key focus areas in that particular program. So what costs and activities are allowed and unallowed, et cetera. So this is a really great tool to be aware of. So if you're one of those under 2 years of experience with federal grants, you just leapfrogged a bunch of people who are around 5 by knowing this trick. And then lastly, I talked about, right, the agency websites. If you take a look at the, let's see, you look at HRSA, Ryan White HIV/AIDS program website, you've got this sounds silly as a lawyer to say, go look at the agency website, but it's typically a treasure trove of useful information. And the agencies are very good about promulgating substantive websites for each program. So this Ryan White example, manage your grant. You can see where it takes you, grant recipient resources, and you've got the legislation, program letters, information about reporting, etc. I'm going to kind of skip over to the policy notices and program letters. This is how Ryan White HIV/AIDS Bureau issues guidance for the Ryan White program. It's going really slow. But they have these things called PINs and PCNs, policy clarification notices, where they address a lot of gray areas that are program specific. So I'm going to stop sharing on that. It's taking a minute for my computer to link over, but I made my point. So let me switch back to the slides. Okay, we're good. So as you're thinking, well, goodness, this is a lot of information for me to run down. How do I do it? The bottom line is start with a knowledge of 45 CFR Part 75, in particular subpart D, which is the administrative requirements, and subpart E, which is the cost principles. And then as you work out from there to investigate program by program what might be additional obligations. So one, it's great if you've got a clear agreement. But two, if you're dealing with the federal government directly, so you're only going to get a very brief notice of award, or you're dealing with the state government where maybe you'll get a very brief agreement, or an agreement that's confusing because state governments tend to be pretty bad at drafting them, then you want to be able to sort of navigate this pyramid. How do you navigate the pyramid? Well, right, based on your knowledge of 45 CFR Part 75, take a look at the assistance listing in sam.gov, take a look at the compliance supplement, and take a look at the agency website and build out from there. And you should be able to develop a pretty good risk profile for that particular program pretty quickly. As you do it multiple times, you'll be able to assess a program and say, 2 to 6 hours without too much difficulty. So the deal. Let me expand this so I can see if any questions. So if you have any questions, go ahead and ask them as we go. So the deal. So within this legal framework, then, what's the deal, right? What are you expected to do? All of the stuff that's covered by that pyramid boils down to what I call the 3 certains. This is something we coined here at the firm, but I think it makes life a lot easier if you look at your grant in terms of the deal and you look at the deal in terms of what we call the 3 certains. And so the fundamental relationship between you and your funder, and I'm going to talk in terms of you as a grantee and the federal government, just because it's easier to talk about it that way, but this is true with pass-through entities as well, is that if you, the grantee, engage in certain activities during a certain period of time, the government will reimburse you certain costs incurred in engaging in that activity. So certain activities during a certain period of time, you'll be reimbursed certain costs of those activities. It's not any and all activities, it's only certain activities. So how we define those activities matters. And that's one key set of sort of requirements that apply under the uniform guidance. It's costs incurred or activities carried out during a certain period of time. So I'll talk briefly about that. It's not right forever. You have a budget period and a performance period, a project period. I'll talk about those. And then it's cost reimbursement. And we'll talk about the payment mechanism, but fundamentally, you're simply reimbursed for actual costs incurred, and you cannot earn a profit on a grant. Now, there's some circumstances around the edges where, for those of you where I see came in with more than 10 years of experience, you could argue that because there's sort of a fixed rate of reimbursement for certain things, you could theoretically have revenues in excess of expenses on a grant. Those are narrow exceptions, and conceptually, they're not intended to be profit. So if you're earning a profit on a grant, yeah, you want to go back and check your systems because something's probably wrong that will lead to a payback. So the certain activities piece, I'm just going to flip through my slides to see what I've got on each of these to remind myself as I get into it. Okay, so the certain activities piece, if you think about, well, wait, what's the government funding? Let's think about our legal framework, and then let's think about how we establish our relationship with our funder. So first and foremost, we think back to that pyramid. And remember, the federal awarding agency, the CDC, right, for example, can't take something of value that belongs to the federal government and convey it to a non-federal party without statutory authorization. Well, that statutory authorization in the form of the Authorizing Act with the appropriations limitations layered on is narrow, right? There's only certain things that are allowed to make the grant for. So in the first instance, the certain activities already you start out in a box, right? You start out with parameters that the federal agency can only award grants or cooperative agreements for certain general purposes. So I'll say it's a medium sort of width, bandwidth of things that they can do. But then that agency says, okay, well, within that scope of authority, I'm going to seek applications for certain categories of activities that I think should be priorities. So they issue a funding opportunity announcement. And then we as the grantees respond to that funding opportunity announcement saying, well, within the scope of that funding opportunity announcement, here are the specific things that we will do within those categories of activities. And this is what they'll cost, and this is how we'll do them. And we compete with each other. And then based on that usually competitive process, the agency will select successful applications and fund them. So what you see sort of happening is that there's a limit to the certain activities scope, that's set by this original authorizing act. And then within that, there's sort of a subcategory of a sort of a sublimit that's set by the funding opportunity announcement. But then at the end of the day, when you submit your grant application and say, these are the things I'll do, I'll serve these patients at these locations, or I'll conduct this outreach in this manner, in these, the following ways, and this is what it will cost me to do that, that grant application that then is funded establishes the boundaries of the certain activities. And the term of art that we use in the grant system for what's the agreed scope of activities that are those certain activities that's funded, we call it the scope of project. So scope of project is that concept, and that term is critically important in managing your grant agreement, because the costs that are allowable costs, there are some limitations on allowable costs that we'll get into, but the costs that are fundamentally potentially allowable costs have to be costs that are associated with those activities. You could do something else that's a really great idea, but if it's not within the scope of project that's funded, doesn't matter what a great idea it is. It's outside the scope of the project. It's not a cost to the grant. It can't be charged to the grant. So certain activities becomes a really important consideration. So the extent, I'm going to come back to this slide, but the extent of flexibility you have to change what you put in your narrative or budget is somewhat in the eye of the beholder, and this depends on the funder. Generally speaking, the funder will provide you with guidance on the narrative side for when you have to come back, and if you're doing something different than what you said in your application, when you have to seek their approval to do that different thing. So on the narrative side, the who I'm serving, the where I'm serving them, et cetera, varies program to program. So as you're doing your evaluation of a particular program, that's something you want to look at. Well, for this grant, how much can I deviate from my narrative and my proposal and still be, consistent with my scope of project as approved? And when do I have to get permission? That's going to be case by case. You want to get a sense of that up front. The budget tends to be more rigid in terms of the set of rules that apply. But when I say rigid, I mean in terms of the set of rules that apply, not in that the budget itself is actually particularly rigid. The rule is, there's essentially two options on the rule. What the regs say, if you read 2 CFR Part 200, if you read 45 CFR Part 75, what the rules and the regulations, what the regs say, and I see my citations here in Part 200, but in your case it would be 75-308. The sub paragraphs I think are the same. What the rules say is that the funder can, if it so chooses, prohibit you from moving money between direct cost categories when movement of money between direct cost categories in your approved budget would exceed 10% of the total grant amount. Which, said another way, is if the movement between direct cost categories is below 10% of the total grant amount, you as the grantee simply have the right to move the money around. Now, your funder may say we want to be notified if you do that so we can track it, but you have the right to, it's called budget flexibility is the concept. You have the right to move money around within your direct cost categories or across your direct cost categories, so long as it doesn't exceed 10% of the total grant amount. Now, some federal agencies use a different higher number. They don't use 10%. So, right, their authority is if it's over 10%, they can restrict you. What HHS does is they say if it's over 25%, we restrict it. You have to get permission. You have to go back and do a budget amendment. If in aggregate during your budget period, you're moving more than 25%, I guess it's 25% or more of total grant amount between direct cost categories. And so that generally is what will be flowed down in the context of a subaward in HHS. So when you think about budget categories, the SF 424 is the standard form that establishes budget categories. HHS, including CDC, though I think CDC may actually have a separate, depending on their what type of award it is, they may add a consultant category. But generally speaking, these are your budget categories. This comes from a standard OMB form called the 424. And the categories are personnel, fringe benefits, which actually gets aggregated into personnel, so it's salaries and then fringe, travel, equipment, supplies, contractual, construction, other, and then indirects. So for budget flexibility purposes, generally what you're talking about is moving money from, say, personnel to travel or contractual to personnel or both. But in aggregate, the movement adds up during the budget period to 25% or more of your total award amount for that budget period. So you got to track it as you go. If I'm a pass-through entity, I like to know even if it's, say, 5% of my total, of the subrecipient's total budget, because I want to be aware of the fact that the budget changes are happening. It's a useful data point. But as far as approval, it's over 25%. So then certain period of time. So what you'll find, by the way, on most other awards is that this is not 25% between direct cost categories. Almost every other federal agency uses 10% of total grant amount. It's just HHS has a much higher bar, or lower bar, I guess, a higher threshold. So certain period of time. So costs that are allowable charges to your federal award, what period of, so the costs that are allowable are costs that are incurred during the budget period that's funded by the award. And so what most federal agencies do, and this is true of HHS, and this is true typically of state governments that pass through HHS funds, is that they'll have a project period that's multi-year, say 3 or 5 years. So let's say it's a 3-year project period. But each of those years of performance is incrementally funded, is separately funded. And what the agency will say, the funder will say, is that you can only charge to the award costs that are incurred during the budget period that is funded by this particular notice of award. And if we fund a future budget period, which we intend to do, that'll be part of your project period, we will separately fund it and you'll have a new budget period. Typically within HHS and within subawards under HHS, that means that you're operating in terms of a certain period of time, year to year to year to year, and that year to year to year to year is grant year. It's your budget period for that grant. If you're an entity that has, with clients that'll have, say, 60 different grants, they start and end at all sorts of different times. So the fact that grant years don't line up is constantly a challenge that has to be managed. But on any individual grant, the costs that can be charged to a particular notice of award, a particular agreement, tend to be costs that are incurred for that budget period. Now, when a cost is incurred is an area where there's a little bit of a gray area, but by and large, costs are incurred for personnel when the personnel does the work. So the day they show up to work and they earn their salary and their associated fringes, that's when that cost is incurred. For contracts, generally speaking, the cost is incurred when you sign the agreement when you enter into the agreement to pay should the other party perform. That's a risk area in the sense that you can't enter into contracts for services that'll be provided way down the road and say, well, it's just when I sign the contract, so I'm going to sort of pre-sign to obligate funds in this period when really I need the services down the road. The further you get from your typical business practices and the further you get from the notion of I'm signing a contract today because the services are needed very soon, the more likely you're actually to have those costs disallowed. This again is a gray area. Generally speaking, it's when you sign the contract. But if you're gaming the system by pre-signing contracts or quote unquote pre-obligating funds, that will become a problem. And so if there's a big disconnect between when you're going to sign that agreement and when the services will be performed, you want to check with your funder on the extent to which they'll grant you flexibility there. That's my recommendation. And then certain costs. So that's the certain period of time. I think I've got that here. And then certain costs. So it's not any and all costs of performance. It's only certain costs of performance. The good news is the way the federal cost principles work is that the vast majority of your routine business expenses are in fact allowable costs. And so there's two. So the allowable costs of performance are costs that are allowable and allocable. Cost allocation is a topic we're going to cover in just a little bit more towards the end. Allowable, allocable means that there's a relationship between the incurrence of the costs and the activity that was funded. So I'll get into that. Basic allowability has two components. So there's a sort of baseline set of standards for allowable costs that you'll see in the cost principles. And that you'll find in the cost principles basically between 200.400 through about 200.417, I think it is, 416, 417. And these are just general standards for allowability. And then from about 417, 418 through like 475, you have what are called the selected items of cost. And so for a cost to be allowable, it has to meet the baseline standards. And then depending, the selected items of cost are this essentially a laundry list of routine business expenses. And within the selected items of cost, there can be additional requirements that apply to that particular expense type. If you are the person who's approving costs that will be charged to an award, it's really important that you're familiar with the federal cost principles. And in particular, so we're going to talk about the baseline standards. Those are easy to learn, but I'm not going to talk in detail about the selected items of cost. People hate to hear me say this, but the reality is if you're responsible for approving allowable costs that are going to be charged to a federal award, you really need to embark upon what I recommend is that you embark upon a selected item of cost a day program, where for every day you read one of the sections of the selected items of cost, and you do it until you've gotten through them 3 or 4 times, which will take you about half a year because there's not that many of them. And by the time you get to the end of that, you will have knowledge that you'll have for the rest of your life in managing federal awards. It'll be very, very valuable to you, and it will save you a lot of heartache and a lot of time in avoiding unallowable costs down the road. No one likes to hear me say, I think you should actually go read the regulations, but in this area, if you're in the finance department, or if you're responsible for approving allowable costs, you should actually go back and read the regs as sort of an educational, self-educational matter, where you just read one a day for 6 months. And we'll talk about that a little bit more in a second. So what are the baseline standards of allowability before we get further into the selected items of cost? So it's essentially a prudent person standard. Costs have to be necessary and reasonable. Necessary and reasonable generally are read together, and it's necessary and reasonable for the performance of the award or the operation of your business. Reasonable costs, and might have a slide on this. Nope. So reasonable costs are defined at 200.404. And the definition of a reasonable cost is a cost that a reasonably prudent person would incur under the circumstances prevailing at the time the decision to incur the cost was made. So it's a prudent person standard based on the information available at the time that you made the decision to incur the cost. It's a pretty simple standard. And then there's some factors for assessing reasonableness, like did you incur the cost in accordance with your typical business practices? If it's a contractual cost, was it the result of an arm's length negotiation? Things of that nature. But it all boils down to your typical business practices and prudent decisions based on what you knew at the time. Allocable, we're going to talk about, conform to the limitations of the cost principles, including the limitations in the selected items of cost. I sometimes have a slide on this. I don't today, but basically what you'll find when you read through the selected items of cost, and the very first one is advertising and public relations. They're alphabetical, and the very last one is travel. But if you go through and you look and you read each one of these, and I recommend, again, like I said, that you actually do sort of pick one up a day for every day for the next 6 months. When you read them, what you'll see is that most of the additional requirements boil down to outright prohibitions based on policy matters, like the government won't fund entertainment, the government won't fund alcohol, the government won't fund organizational restructuring costs, the government won't fund lobbying expense, the government won't fund certain legal costs. Generally speaking, sort of compliance costs are fine, but legal costs where you're bringing a claim against the government won't pay basically allow you to pass your legal fees through to them through your grant. So certain areas where there's a policy reason that the government says, look, we understand it's a routine business expense, but we're not going to participate in that with taxpayer funds. Then there are additional documentation requirements. A great example of this is the selected item of cost for personnel expenses has a special documentation requirement, and that's where time and effort documentation requirements come from. I'm going to talk about those in the cost allocation section because it's really a cost allocation function. And then there are limitations on valuation of costs. If you have a less than arm's length lease transaction, you can pay fair market value all day long, but the most you can ever charge to your federal grant is the equivalent of ownership costs. If you own the thing yourself that you're getting now through a less than arm's length lease transaction, things of that nature. And I'm not giving you these examples so that you memorize these particular rules that I'm using as examples. I'm giving you these examples to give you a sense of what you'll find in the selected items of cost and why it's important to actually become familiar with each of those individual cost categories. It'll take you time. And then the rest of the requirements that you see for basic allowability are sort of things that we've already talked about. Timing, and consistency. So consistent treatment. If you charge a cost, this talks about consistency between both federally funded and non-federally funded activities, and consistency between in how you treat costs as direct or indirect. I'll speak to the first bullet briefly, which is if you treat a cost as a cost that a prudent person would incur when you're charging it to a federal award, but then that same cost, if you have to absorb that cost with your own funds, you treat it as a cost that a reasonably prudent person wouldn't incur, that's potentially going to cause you problems. You never want to have an expense that you say, well, we'll allow this cost internally, we'll pay this cost only when we can charge it to a federal source. Generally speaking, that disparate treatment between when the federal government's picking up the dime and when you're independently picking up the dime will become a problem. So engaging third parties. So we're going to come back to cost allocation in a minute, but I want to talk first about engaging third parties. So there are distinctions within the system between contractors and subrecipients. So when you're the grantee or subgrantee and you're funded, right? You're receiving federal funds through a grant agreement, and you want to work with third parties to help you carry out your project activities. Under the uniform guidance and under the OMB circulars that preceded the uniform guidance, there are two basic categories of partners. Theoretically, there could be other categories of partners as well, and every now and then we'll work. A good example of that is if you furnish healthcare services to a beneficiary, and then you're paid for those services but if they have insurance, right? You're paid for those services by the payer. That arrangement, that contract to be paid, that provider agreement you have with the payer, right? They're not a contractor or a subrecipient. There are other types of agreements that can exist, but when you're bringing another entity into the performance of your project in some way, there is a really heavy bias in the regulations in favor of you finding that relationship is either a contractor relationship or a subrecipient relationship. The regulations don't really contemplate other types of relationships. So the vast majority of the time that you're paying a third party to do something that furthers your grant-funded activities, if you're the one paying, at least, the vast majority of the time, they're going to be classified as either a contractor or a subrecipient. Now, I'm going to talk about these definitions a little bit more, but I want to say one other thing before I get onto those slides. The concept of contractor, historically under the OMB circulars, they were described as vendors. I liked that a lot better than the term contractor, because you'll have a lot of agreements with entities that are called contracts, and Kathy mentioned this with the state of Tennessee. They call their grant agreements grant contracts, right? They are contracts, they're common law contracts. Contractor, for purposes of the uniform guidance, means, and this is why that language that Tennessee uses feels a little confusing, contractor for purposes of the uniform guidance means vendor. It's an entity that you're paying for goods or services. Subrecipient, by comparison, under the prior OMB circulars, was actually described as a subgrantee, which I think is a much clearer description. So subgrantees, sub-cooperative agreement holders are subrecipients. Those legal arrangements are called subawards, whereas contractors is what we used to call vendors with whom you'd have contracts, or what I would call procurement contracts. So you will recall this slide, right? So here on the financial assistance system side of this slide, you have your financial assistance award. In this case, most of you are here. And as you bring partners into your project, some of them will be vendors and some of them will be subgrantees. I suspect in your case, actually, they'll end up all being vendors. You have to get prior approval. I'm going to talk about this for subgrant, or as we call them, subawards or contracts. Talked about this already. So the regulations, the uniform guidance provides, and it's the same standards in Part 75. I see my references here in Part 200. The uniform guidance provides a definition of subawards, and it provides a definition of contractor relationships. The definition of subawards and the definition of contractor relationships that it applies are very, very similar to what I described early on when I was talking about a federal agency having two choices. You'll recall that the way I described the federal agency's decision-making was that if what it wanted to do was to acquire goods or services for its own consumption and carrying out its mission, then it would use a procurement contract. If what the federal agency wanted to do was take something of value that was in its possession and convey it to a non-federal entity to encourage that non-federal entity to engage in an activity that had a public purpose, it would use a financial assistance award. So sub-grant or grant or cooperative agreement. It's essentially that same definition, which actually originates in something called the Federal Grant Cooperative Agreement Act, that you then, as the financial assistance recipient, are using under the uniform guidance to decide between subawards and contracts. What the regs provide us certain characteristics that we'll typically see, according to the regulations, we'll typically observe in a subrecipient relationship or a subaward relationship. And they provide us certain characteristics that you'll typically see in a vendor type relationship. I have to share these to describe this topic because it's what's in the regs and it's what your auditors will talk about. But I will tell you that for most of the gray area agreements, these standards aren't very helpful. There are some unspoken standards that I'll talk about briefly that are much more helpful. But in any case, typical characteristics for a subaward, what the regs tell us is that typically performance would be measured against the objectives of the federal program. You'd be delegating responsibility for programmatic decision making, and the subrecipient would be required to adhere to federal program requirements. In obvious subaward scenarios, these are all true. Unfortunately, in a lot of contractor type scenarios, some of these are true as well. So what ends up happening, and let's talk about the characteristics of a contract, and then I'm going to talk about the gray area, and I'm going to talk about the unspoken rules. So typical characteristics in the contractor scenario, the vendor agreement scenario, would be that the entity provides goods and services within their normal business operations. They provide the same goods and services to many different purchasers. And the goods and services are of such a nature that they're ancillary to the operation of the federal program. And then the agreement wouldn't necessarily flow down all the terms and conditions of the federal program into that agreement. And that's true. A good example of this is your contract with the whatever entity you buy the rubber gloves from, or the tongue depressors, or your contract when you go to Staples and buy stuff. It's hard to imagine them as a subrecipient, right? Because they're a commercial entity that you're just buying supplies from to carry out your program, your federally funded activities. By comparison, well, let me come up with a gray area example. Where the challenge comes in is where what you want to do is you want to say, I want to take some of the funds that are available to me as a grantee, and I want to take a piece of those funds and convey them to another entity. And I want that other entity to do things that feel like they're programmatic in nature. So in the healthcare context, we often see this. So a Section 330 recipient, for example, a community health center. Let's say that they want to engage another entity that's similar to them, or Ryan White provider in their local trade area. Ryan White's even better. So you're a Ryan White provider, you receive Ryan White funding, and you want to see more patients. And there's another entity that's similar to you down the street. It's a nonprofit healthcare provider, and you'd like them to see some of the patients. You want to expand your capacity by having them see patients. And so what you want to do is you want to engage them to see some patients for you certain days of the week, and then you want to report those patient numbers under your grant program. Well, in that scenario, you really theoretically could structure the relationship as a contractor relationship or as a subrecipient relationship. It's kind of a gray area. On the one hand, right, you could go to that similar entity down the street if they're otherwise eligible to be a Ryan White recipient. You could say, look, I'm going to subaward funds to you to make you a Ryan White subrecipient, and you have to comply with all the terms and conditions of the federal program. I want you to see patients, and I'll reimburse you for the actual costs of seeing those patients, right? Just sort of a mirror image of your relationship with your funder. On the other hand, you could go to that entity down the street and you say, look, I just want to purchase some hours of your physician, and I want your infectious disease physician to see these patients certain days of the week that are my patients. I'll refer them over to you. I'll pay you some flat fee amount per hour, or some flat fee amount per patient seen. And then I want you to report back to me what it is that you did in those visits, and we'll enter into arrangements to make sure it's HIPAA compliant. And so in that sense, you could actually structure that relationship as a vendor relationship. You're just paying the physician for services. So you can see that there are sort of these wide swaths of gray between subawards and service contracts where you'll have to exercise discretion as the grantee. What ends up happening, or what matters as you're exercising that discretion, is that if you're entering into a vendor relationship, the legal requirements that apply to that vendor relationship under the uniform guidance are very different than the legal requirements that apply to that relationship under the subaward framework. In the subaward context, the rules that apply are all focused on risk management, or mostly focused on risk management. So first and foremost, when you want to make a subaward, you have to get approval of your funder. Every single subaward requires prior approval of your funder. Whether that's directly the federal government or whether that's going to the state of Tennessee and getting the approval, every subaward requires prior approval. Subawards do not have to be competitively awarded. You can just choose, so long as they're eligible to be a subrecipient, you can choose who you want to work with, and then as long as you get your prior approval, you work with them. There's no competition process. Now, it may be that a state agency will use a competitive process to award its subawards. That's generally speaking because of their choice and their state laws. It's not a federal requirement in most cases. Some programs will have requirements for competitive awards, but it's very rare in the healthcare context. When you enter into the relationship, you're then required to basically establish that relationship with the subrecipient as a mirror image of your relationship with your funder. You have to flow down all the terms and conditions that apply to your award down to that subrecipient. And then you have to do oversight with respect to that subrecipient. You have to assess the risk of their non-compliance with federal obligations. That's flowed down through you. And then you have to implement oversight mechanisms, including routine invoicing, routine financial reports, routine programmatic reports that enable you to oversee, and that actual, in my view, on-site, site visit type oversight in most cases, to provide you a reasonable assurance that that subrecipient is performing in a manner consistent with their obligations under the agreement. It's a risk management endeavor, but it's not a competitive award. You just need to get that prior approval. By comparison, if what you want to do is just hire that doctor down the street to see some of your patients, you can structure that relationship as entailing far less oversight in the course of their performance. But the federal requirements that apply to your establishment of that relationship are the federal procurement standards. And they very heavily emphasize and require competition in the establishment of the relationship. So you can't just necessarily say, I want to go work with that particular doctor down the street and choose them. If the contract is over $10,000 in value, you have to engage in a competitive process to select that party, that vendor, because they'll be operating as a contractor or as a vendor. If it's over $250,000, the value of that contract, which I understand that in the case of most of your subawards from TCCN, your vendor arrangements won't be over $250,000. But if that arrangement is over $250,000, you're required under the federal procurement standards to use a really formal competition process that includes either an invitation for bids or an RFP that's widely publicized, and that you consider all the offers that come in. So on the procurement side, if what you're doing is entering into a procurement contract, or if what you're doing is engaging a vendor, whether it's in one of these gray areas or if it's just an obvious vendor arrangement, right? You're hiring the printer to print your outreach materials. If that contract is over $10,000, you have to use a competitive process, generally get 3 quotes. And if that contract is going to be over $250,000, you have to use a formal competitive process that involves either a widely publicized RFP or an advertised invitation for bids. Now, I believe we're doing a follow-on webinar that's specific to the federal procurement standards. And Kathy, can you give me a thumbs up if I've got that right? Yes. And so I'll get into all the rules about vendor arrangements, procurement, competition, and the award process when we do that one. There's a ton of detail in that area. But for today's purposes, keep the goal, or the main point is that subawards and contractor relationships are different. Subawards are all about flowing down, getting prior approval, then flowing down the terms and conditions of the prime award, and then oversight and collaborative performance in the course of performance. Whereas on the vendor side, managing the relationship's a lot easier, the contractor side, but there are a ton of requirements about how you enter into those contracts, and in particular, the competition in the award of those contracts. So, cost allocation. So, cost allocation is the idea that, or cost allocation is the area of federal grants practice, maybe is a better way to describe it, where what you're doing is you're saying, okay, I've got costs that are fundamentally allowable costs, right? That under the selected items of cost, under the general standards, right, that of the cost principles, a prudent person would incur the cost, and under the selected items of cost, I don't have any limitations that would prove barriers to my incurring this cost and charging it to a federal award. But cost allocation is so I've got fundamentally allowable costs, but the question remains is this actually a cost of the certain activities, right? The funded activities, when we think of our three certains. Some costs are easily identifiable with your set of funded activities. The only reason you're incurring the cost is because they have a relationship, a beneficial connection to those funded activities. Those are your quintessential direct costs. The only reason you're incurring them is because of this set of funded activities. But a lot of your costs are what we would call joint costs. You incur the cost because that cost will have a benefit to your set of funded activities, but also to other activities that are outside the scope of your grant project. And so then the issue becomes, well, how do I allocate a portion of that cost to my grant project and a portion of that cost to my other activities? And there's really two tiers to these costs. There's your costs that you're incurring as direct costs and allocating out to all the benefiting activities through some sort of allocation methodology, and we'll talk about examples. And then there's the costs that really benefit your organization as a whole, which you choose to recover through an indirect cost rate agreement. And I'll talk about that process as well. I suspect, in fact, I'm going to do a quick ad hoc poll here. How many of you have, if you have a direct, if you could just put into the chat, if you have direct federal awards, or in fact, I'll be more specific. If you have an indirect cost rate agreement, say yes, just type yes into the chat box. You'll know if you have an indirect cost rate agreement. So if you don't know, don't type yes. If you have one, go ahead and type yes. It's going to be only your direct federal recipients for the most part. So either no one's listening to me or no one has indirect cost rate agreements. All right, I'm only going to be really brief on that point then, because I don't think it's going to be of use to you. All right, well, thank you for the no. That's actually helpful. All right, no one has one. So I'm going to be, I'll be very brief on that point. I'll tell you what they are, but I'm just not. So generally speaking, then all of the costs for you are going to be direct costs. Direct costs, a lot of people get confused about what's a direct cost and what's not a direct cost, because a lot of people will think, well, if I have joint costs, if I have a cost that benefits multiple activities that I'm accumulating in sort of a joint direct cost pool, and then allocating out to the benefiting activities where my finance department is over some sort of metric that reflects benefits, sort of proportional benefits received from that cost that I'm incurring, and I'll give you an example of this with facility costs, then that feels like an indirect cost. But in the federal grant system, if you don't have an indirect cost rate agreement, all of your costs are direct costs. They're all direct costs. You choose to have indirect costs by negotiating an indirect cost rate agreement. And the idea, I'll just say it now, with an indirect cost rate agreement is that there's some costs like your executive team, HR, IT, things of that nature, that you don't want to have all these little joint direct cost pools you've got to manage, which will make more sense when I talk about facilities in a minute. You don't want to have all those little pools that you have to manage. So what you do is you take them all and put them in one. Go ahead.
Sorry, this is Mary. I just wanted to share just I think it's helpful to this conversation that our members don't have negotiated indirect cost rates, but we're using the de minimis on sub awards.
Oh, okay, great.
Yeah,
Thank you.
Used, yeah.
That changes things. That makes a difference. So so let's say you haven't negotiated an indirect cost rate agreement, but you are using the de minimis rate. So conceptually, that 10% represents something. And it is. It's going to be things like your executive team, IT, HR, etc. And the idea is, instead of having those costs detailed out with a cost allocation methodology to recover them against your awards, you've said, look, I'm going to take all of those. I'm not going to directly charge them. I'm going to put them all in one big bucket, sort of, at the top of my organization. And I'm just going to say that for every dollar of direct costs I charge to my award, I'll take another 10 cents. And it's not actually every dollar. It's every dollar of modified total direct costs that you charge to your award, which I'll talk about in a little bit. I'm going to take another 10 cents that represents a little sort of tiny piece of that big bucket. So it's a very rough justice way to be able to recover some of those overhead expenses that you're not charging directly to your awards. The only difference with a NICRA, a negotiated indirect cost rate agreement, is instead of automatically taking 10% over modified total direct costs, you actually negotiate what's in the pool and what's in the base and come up with a number. And then you have to adjust it year over year in most cases, but I won't get into that. So let me talk about the baseline standard for cost allocation. And then I'm going to go to an example because I'm looking at the time here. And so the baseline standard for cost allocation is that if you want to assign a cost as compensable, assuming it's fundamentally allowable to start with, you want to allocate a cost to a federal agreement. You want to assign that cost to a federal agreement in whole or in part as compensable under that agreement. The baseline standard is that the extent to which you assign that cost to the agreement has to be based on a beneficial relationship between the cost incurred and the activity. So the standard for cost allocation is that it has to reflect relative benefits received. So the activities, right, the underlying activities receiving benefit from the cost you're incurring. The standard for how detailed documentation you have to have for that cost allocation is a sliding scale standard, meaning if the cost is associated very clearly with just that set of activities, then the expectation is you'll have very specific documentation showing that that cost is associated with just those activities. But to the extent that that cost benefits multiple activities in a less direct way, like you'll see when I give you the facilities example, you're allowed to the increasing extent that that connection is less clear, so long as the methodology you're using to assign that cost to the benefited activities is consistent across your whole organization and reasonable in terms of its sort of fairness over time and allocating that cost to all the benefiting activities, the less you're required to have a very specific allocation methodology. So what I want to do, I'm just worried about the time, is I want to give you an example of that in terms of, I'm going to skip the poll question, in terms of a facilities expense example. So let me switch, because this is a picture is worth 1,000 words moment. Whoops, I lost my thing here. All right, bear with me. Oh, stop sharing. All right, I'm going to share my other screen. Okay. So can you see the OneNote? Kathy, thumbs up.
Yep, we see it.
Okay, great. So imagine, so a great example of cost allocation that I think is fairly easy to conceptualize is facilities. So let's say you have facility expense and you don't recover your facility expense as part of your 10% through your modified, right, through your de minimis rate. Let's say you're direct charging facility expense. That's a choice you have. And so what you choose to do, or so let's say you've got a really simple facility. Let's say it's 10,000 square feet. And let's say roughly your facility is divided into equal quarters for what you're doing in the facility. So the usable square feet of your facility, let's say performance of grant A takes up 25%. Performance of grant B and C takes up 25%. Performance of your non-federally supported activities takes up 25%. And then your administrative space, your HR, IT, et cetera, executive team takes up about 25% of your space. So what your facilities cost, ignoring certain timing issues, just thinking of this in terms on a, let's say, a grant year basis, your facility expense will consist of costs like, let's say you let's say you own your space. So you own your space with depreciation expense, maybe mortgage interest. You've got a mortgage, janitorial, security, utilities, right? Insurance, right? So let's say throughout the year, ignoring some timing issues, let's say that this all adds up to $100,000 a year. $100,000 a year. Well, if I were to ask you how much of that $100,000 a year should you allocate to each of the benefiting activities, I think most of you would look at this diagram and say, well, of that 100,000, I'm going to charge 25,000 to grant A, 25,000 to grants B and C, 25,000 to my non-federal activities, and 25,000 to my administrative sort of overhead pool. And that makes a lot of sense, right? And what you're saying when you do that, you're saying, well, what I'm looking at is under the diagram that Scott showed me, what he's showing me is that 25% of my usable square feet are used, right, or occupied by each of these things. But then you're going to be thinking to yourself, well, wait a second, but he didn't differentiate between, right, between B and C. So I've got $25,000 to BC, but how do I differentiate between grant project B and grant project C? Well, if you're using a direct allocation methodology, one common way to do this is to look at, well, for grant B, what's my direct labor expense for the period, right? And for grant C, what's my direct labor expense for the period, right? How much am I paying my people, or what are my people doing? Or maybe proportional head count. And then to further allocate this 25,000 over, right, proportional direct labor. So that way it gets out to then, right, grant B and grant C. This isn't necessarily how you have to do it. This is a common methodology that you might use. With the admin, right, for those of you who have a de minimis rate where you've said, look, I'm going to recover my admin costs, I'm going to recover my overhead indirects by using the 10% de minimis rate. Well, this goes into your 10% over modified total direct cost de minimis rate that you're using. So, make sense? When I say it goes into, right, you don't ever have to technically calculate that rate, but you want to be able to support that rate. And so this expense would be a good example of the type of expense that you wouldn't be recovering directly because you're already recovering it theoretically through that 10%. So that's the concept of direct allocation of joint costs. It's a concept of creating a joint direct cost pool for occupancy costs, for example. The other place where you will have, and I'm not going to talk about federal interest today. If anyone has federal interest questions, well, I would say pose them to TCCN. And Mary, I am more than happy if you get a list of questions to help you prepare a list of answers as part of the feedback on this webinar on federal interest, because I know that I've run out of time here almost. But I want to talk about time and effort without rushing too much. So time and effort is actually a fairly simple concept, but time and effort documentation, timesheets, this is really a cost allocation because that's the facility example. Time and effort or timesheets conceptually is a cost allocation function. So it's a documentation requirement that you find under the cost principles. But the reason it exists under the cost principles is because people are a quintessential, very common joint cost, right? A person does more than one thing quite often. If a person does more than one thing, then the cost of that person, so when your finance department is paying their salary and their fringes and paying taxes on their salary and fringes, to the extent that that's happening, that cost your organization is incurring, well, if that person only does one thing, well, that's a cost to that one thing. But if that person does multiple things, you need to allocate that cost among the benefiting activities. And you have to have reasonable documentation of how you're doing that. So that's what time and effort is all about. This is your cost allocation documentation for personnel. Historically, the standard for time and effort documentation, this is the current standard. I'm going to talk about the historical standard. I'm going to talk about the current standard. The historical standard for nonprofits was that you had to have actual, no kidding, personnel activity reports, so timesheets, for anyone who was charged in whole or in part to a federal award. And the standard was that those time sheets, the PARs, personal activity reports, had to correspond to pay periods and be done no less than monthly. The historical standard was also that they had to be signed by either the employee or the employee's supervisor who had direct personal knowledge of what the employee did. It's a very high standard, very strict standard. The standard for state and local governments that used to exist was a little bit more flexible, and it's the standard that I like today. The standard for state and local governments was that if a person split their time between multiple activities, they had to do PARs. So the employee or the supervisor, right, at least monthly, had to sign off on a piece of paper that said how they split their time. Not necessarily at the hour level, but at least at the percentage activity level. I spent 20% of my time on grant A and 80% of my time on non-federal activities, at least monthly. But if a person didn't split their time, if they only worked in furtherance of a single cost objective, so only on the grant, only on some other activity that isn't the grant, only on administrative activities, then the person was allowed to simply sign or provide the grantee organization could simply obtain from that person a biannual certification from that individual that said, all I ever do is this one thing, and that was adequate. The current standard, the standard historically for universities was incredibly flexible. I'm not going to go into it today, but if you're doing business with a university, their expectation is that these standards, because of historical experience, are much lower. The current language in the selected item of cost for personnel expense is at 2 CFR 200-430I or 45 CFR 75.430I, same numbering essentially. And the standard is that the charges for personnel have to be supported by records that are in turn supported by a reasonable system of internal control that provides an assurance or a reasonable assurance that the charges are accurate, allowable, and properly allocated. So this gives you more flexibility in the sense that you have to have a system of internal control that results in records that accurately reflect the work performed. The downside to the fact that this standard is a little more flexible than the old standard is a lot of grantees then wonder, well, what should I do to actually implement it? My advice to grantees is generally to adopt the old state and local government standard under the old OMB Circular A87. My view is that best practice is that if you have a person who's splitting time, they should do timesheets no less than monthly, at least at the level of detail of 80% on the grant, 20% on activity, other activity, or 35% on the grant, 50% on general admin, if it's say the CFO, and what's the difference? 15% on some other grant. But at that level of detail, at least those percentage breakdowns, ideally by pay period, but at least monthly for people who are splitting time, and then for people who aren't splitting time, biannual certifications. I really like the old A87 standard. If the OIG comes in and looks at you and you're operating to that standard, you're going to be in good shape. If you're operating to any lesser standard, it's more questionable. So indirect cost rates, talked about this already, but the idea is, this is just a picture of it, aggregating all of these overhead type admin costs into one big pool, and then using a mechanism to distribute them out to all the benefiting activities. And federal interest, we're at 130. So federal interest I didn't get to today, but if anyone has questions about federal interest, if you're acquiring capital assets with federal funds, which I think most of you are not doing, but if you are acquiring capital assets with federal funds and you've got questions about this, email them to Mary, and Mary, I'll be more than happy to work with you to prepare written answers that we can distribute to everyone. So with that, I'm happy to hang around for questions, but I don't want to keep everyone. I'll follow your lead, Mary.
Thank you so much, Scott. I don't see any questions missed in the chat. So thank you all for joining. We will distribute the recording. Of course, if anybody has a question, feel free to speak up now. Also want to emphasize that, I think Scott did a great job covering a lot of information in a relatively short amount of time. As always at TCCN, we are here to help you all. So don't want you to feel, any sense of overwhelm. If you have any questions, you can follow up with us. And we'll bring them to Scott and Kathy if and when we need to. But we're here to help, and we're in this together. So appreciate everyone's time today. And thank you, Scott and Kathy.
Our
Thank
pleasure.
you, guys. That was great. just just as Mary mentioned, a lot of information, and it was very informative. And thank you for like the breakdowns and the graphic helps or tools.
Our pleasure. I can't learn just hearing. I have to see. So I try to do that for other people as well. I'm a visual learner. Kathy's explained the same things to me 10 times until she drew me a picture. I didn't get it.
Yeah, very useful. Thank you very much for that.
Have a great afternoon. And Mary, as you get questions, etc., please don't hesitate to reach out to us. We're happy to be of help.
Sounds good. Bye, guys.
Thank you all. Take care.